And the presentation is basically broken down into two parts. I'm going to do the first part, and then my colleague is going to do the second part. So I'll pause at the end, and if you have specific questions, we'll be happy to take them then. So my name is Carrie Kilcoyne. I'm an Assistant Attorney General in the Division of Open Government in Boston, and with me is the Director, Assistant Attorney General, Carrie Benedon, and she's going to do the second half of the presentation tonight. Before we actually get into the open meeting law, we just want to let you know that the Attorney General's office represents residents of the Commonwealth, State Department, and other officers and commissions and groups of consumers. And we do that through, investigation and enforcement, prevention, and certain policy. So here are some other issues outside of the open meeting law that might be of interest to you just in your everyday life, so that, if you have this issue, we have a Public Protection and Advocacy Bureau, which can help you through some of those issues, such as, ensuring your workers are paid the right amount of wages, if you have landlord-tenant issues, or loan issues as a homeowner, other scams that you might be been involved with as a consumer. Just to let you know again that there are other divisions within the Attorney General's office that might be able to assist you. And then finally, our main office, we are both based in Boston, but we have offices throughout the Commonwealth in Bedford and New Bedford and Springfield and Worcester. So we are throughout the Commonwealth here at the Attorney General's office. So let's get into the open meeting law. So the purpose of the open meeting law is to recognize that there's a balance between government accountability and government efficiency. And basically that tries to ensure transparency by the public bodies so that they post notice of meetings, that their meetings are open and accessible to all individuals, and that individuals can attend those meetings and hear and see what's happening. But at the same time, it recognizes that public bodies want to efficiently and effectively manage their operations, and so it allows public bodies to meet in executive or closed session for certain reasons, which we'll go over later, and then to maintain the confidentiality of certain documents that they might be using in those executive sessions. So what is the Attorney General's role in enforcing the open meeting law? So, one of the big pieces is to educate and train public officials and individuals on the law itself. And we do that like we're here tonight. We hold spring and fall in-person regional trainings. We also do webinars once a month, and you can find all this information on our website. The next webinar is in December. We had just had one recently last week this month, but we have one next month, and we try and hold them every month at various times during the day. We also promulgate regulations, which we did a couple of years ago. We revised the regulations. You can find a copy outside on the table if you didn't pick one up. I think there are still plenty of copies out there. They're also on our website. We provide guidance on the open meeting law. So we maintain a telephone hotline as well as an email address that you can call us or email us a question. We have someone who monitors both the phone and the email every day. We try and respond to you within one business day. So if you do have to leave, generally when you call the phone number, you'll have to leave a message, but please don't dismay. We do check that voicemail regularly throughout the day. So it won't just be sitting there forgotten. We will get back to you if you do have to leave a message. Obviously, we address open meeting law complaints. So if an individual alleges that a particular public body has violated the open meeting law, they might file an open meeting law complaint, and we'll go into how that's done later. If they're not satisfied with the public body's response, they can request further review from our office, and we will investigate that complaint and determine whether or not a violation has occurred. And then finally, based on what we found throughout that investigation, we will make findings. We generally issue a written determination. We might find, that there was a violation or there was not. We might impose certain requirements. We might order public bodies to do certain things, such as release minutes or other appropriate action. So if you are a public body member, you are required to sign this certification form. And basically the materials are distributed to you when you take the oath of office, or if you're not required to take an oath of office upon your appointment. They're generally for local public bodies. The material is going to be distributed to you from the clerk, from the town clerk. If you're a member of some other kind of public body, it would probably be from the appointing authority or some kind of administrative assistant. So generally, when you receive the certification, you sign it within 2 weeks of receipt. And basically, by signing it, you have certified that you have received the material and that you understand and read the open meeting law and understand the consequences for any violation. So the material that you would receive is the open meeting law guide, the regulations and the law. Those are all contained within the guide. As well as you're also required now to review the last 5 years of determinations that have been issued against your public body in which our office has found a violation of the law. And basically we did this so that if you become a member of a public body, a new member, you just want to be aware of what the public body has done in the past, and if there has been a violation, you just want to make sure that you read what that violation is so that you're not committing it again. Because if you do commit a violation a second time after you have been warned, it can be considered an intentional violation, which may come with a civil monetary penalty. So basically, the individual who provides that material to you, once you sign it, you're supposed to return that certification form back to the individual who provided it to you. Our office does not need a copy. You know, it might be a good idea for you to keep a copy yourself, but our office does not need a copy. You would return it, for example, to the town clerk if he is the one who provided that material to you. So you will sign a certification upon your re-election or reappointment. So if you're running again for the same public body and you're reappointed or re-elected, you would have to sign another certification form. If you're just becoming a member of a subcommittee, you would not need to sign a certification form. So there are some basic requirements of the open meeting law that you want to keep in mind as we go through the presentation tonight. And the first is that notices have to be posted for all meetings. Meetings must be open to the public, and that a public body can only enter executive session for one of 10 enumerated purposes. Meeting minutes must be kept for all open and executive session minutes. And then finally, there's a complaint process whereby an individual who believes a violation of the open meeting law has occurred can file a complaint and file it with the public body. So the open meeting law only applies to public bodies. So what is the definition of a public body? It is a multi-member board, commission, committee, or subcommittee, however created, elected, appointed, or otherwise constituted, that's established to serve a public purpose. So basically, a public body has to have multiple members. One individual is not going to be a public body. A public body can be called a committee or a commission or a task force or a working group. It doesn't really matter what it's called. If it satisfies this definition, then it's considered a public body and it needs to comply with the open meeting law. So a subcommittee, which is generally a smaller subset of a parent public body, is also considered a public body itself and must comply with all of the open meeting law requirements that the parent public body would be complying with. Generally, a subcommittee is just a smaller group that's tasked with a specific function, and then it's going to report back to the parent public body on what it's been tasked with. Now, there is an exception to this definition of public body, and that's the Connolly exception. And basically what that says is that where a public official creates a group to advise that public official on a decision that he or she has the sole authority to make, then that group is not subject to the open meeting law. So what happened in Connolly is that the superintendent, by law, had the authority to appoint an individual or a candidate for principal. And the superintendent decided that he needed assistance in making that decision. So he created a separate committee to help him choose a candidate for principal. And what the court said is that because the superintendent, as an individual public official, was not subject to the open meeting law, and he had the authority to make this appointment, that any group that he created himself would not also be subject to the open meeting law. And so the distinction is if the school committee, for example, had the authority to appoint a candidate for principal and then created a separate body to assist it, because the school committee is subject to the open meeting law, then any body that it created would also be subject to the open meeting law. But because an individual public official, such as the superintendent, is not subject to the open meeting law, and he had the authority to make that appointment on his own, any body that he created is not subject to the open meeting law. Now, there are some specific exclusions that are written right into the open meeting law of what would not be a public body. And one of those is the legislature, so the House and the Senate. They basically wrote the law and they wrote themselves out. They're not subject to the open meeting law. Bodies of the judicial branch, so for example, juries would not be subject to the open meeting law. Generally not-for-profit organizations, so for example, like 501c3, kind of charitable organizations, generally we have found not to be public bodies that would be subject to the law. Bodies that are created by one of the constitutional officers that are used solely to advise that constitutional officer. So for example, if the governor, the lieutenant governor, the secretary of state created a public body to advise him or her, that public body wouldn't be, that body, or entity wouldn't be subject to the law, wouldn't be considered a public body. Bodies that do not serve a public purpose, so for example, maybe a retirement planning committee. We found those types of groups that they don't really serve a public purpose, they're just, their function is one specific limited act, so they're not really considered public bodies. And then finally, groups that we've seen to be more of a focus group, that they don't really have any jurisdiction, they don't really make any decisions. There's not a specific requirement of how many people need to attend these meetings. Generally, those are focus groups. So, for example, individuals in a neighborhood who might get together to discuss issues that are happening in that particular neighborhood generally are more like a focus group that wouldn't be considered a public body subject to the law. So what is an example of a public body? So on the state level, you might have, for example, the Open Meeting Law Advisory Commission, Board of Trustees of state universities, the Massachusetts Gaming Commission. On a local level, you have Board of Selectmen, Planning Board, Finance Committee, School Committee. A regional level is, regional school committees. Generally, any types of commissions or committees that serve more than one municipality. And then finally, on the county level, where that still exists, you'd have Board of County Commissioners or county retirement boards. So here are some examples of, again, what would not be a public body: the state legislature on the state level, on the local level, or the regional level, maybe regional high school booster clubs, and then on the local level, generally your Republican or Democratic town committees, we have not considered to be public bodies subject to the open meeting law. So the next step in determining whether or not the open meeting law applies is to see what the group is doing, and specifically, are they deliberating? And so the definition of deliberation is an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. So it's generally any communication, which means, the communication doesn't have to result in a vote or a motion. Anytime a quorum of a public body is discussing board business, that is considered a communication. And it can be through email, it can be over the phone, it can be in person, it potentially could be through text message. So what is a quorum? It's basically a simple majority of the members of a public body. So here you see sort of 5 faces, so a quorum of 5 would be 3. A quorum of 7 would be 4. So just a simple majority of a public body.
As a clarification on the quorum issue, please.
Sure.
You said that it talks about a simple majority of the members appointed to the board.
Yes.
So if you had a 10-person board appointed, say, by the Board of Selection, and one of those people was appointed, they used the term ex officio, say like a town accountant. In terms of quorum purposes, would the quorum be considered on the 10, or would the quorum be considered on the 9? If all they did was just state in the charge, we're appointing these 10 people and Mary Smith is ex officio.
Generally, we've considered like alternate and ex officio members to not be like voting members and therefore not considered for purposes of a quorum.
Thank you.
Sure. So here are some examples of what is not considered deliberation. So technically you could do these things, you know, if these things happened among a quorum, they might not be considered deliberation. One of them is to distribute meeting agendas or to discuss scheduling or procedural information. So you could technically email amongst each other certain topics that you might want to see on the notice, but you shouldn't explain or discuss why you think those topics should be there or the significance or importance of those topics. Just that I would like X topic to be put on the agenda for the next meeting. That is a type of discussion that would not be considered deliberation. You can distribute documents or reports to each other, generally so that you can have them for the next meeting to review and be prepared. Just make sure that those documents don't include your opinion. So, for example, you could email to your members an article that you think might be relevant to a discussion that you're going to have at the next meeting. So what you would do is you could send that article to the members. Just don't say, I mean, you could basically say, please review this article for the next meeting. What you couldn't also include is why you think that article is relevant. So you don't want to say, you know, I think this article is relevant to the discussion that we will have pertaining to X topic because. That's going a little too far. I think that would be considered deliberation, which would be outside of a meeting. Communications between a sub-quorum is not considered deliberation. So a sub-quorum is simply less than a quorum. So if you have a 5-member public body and you have 2 members discussing board business outside of a meeting, technically that would not be considered deliberation because 2 is a sub-quorum of the 5. 3 is the quorum, 3 is the majority. So if you had 2 members discussing, it might not be considered deliberation as long as those 2 members are not a separate subcommittee. If they are a separate subcommittee, then any discussion about subcommittee business among a quorum is considered deliberation and has to occur in a properly posted meeting. So just to keep that in mind.
Point of clarification?
Yes.
So if I were to have a discussion with one member and discuss the topic, and then discuss it with another member, which is now a quorum.
Yes, I was just actually
sorry.
going
I
to
jumped
right to
ahead.
that. No, that's a perfect segue. So that is, we have considered serial communication. So that's what your example, I was just going to give that as well. If you have member A speak to member B, and that's only 2 members of a 5-member board, that's a sub-quorum. But if then, for example, member B talks to member C and says, oh, I just talked to A, and this is what we discussed, now you've involved 3 members, that is a quorum, and that would be considered deliberation. So obviously this happens occasionally, especially with email, because it's very easy to hit reply all instead of reply. So just to keep that in mind, that even though you might have initiated the conversation with only 1 member, which was less than a quorum, if another member loops in someone else, you could reach a quorum in a serial fashion without ever intending to do that. And then finally, sort of the last piece of, yes.
Sorry, I understand the definition of a subquorum, but can you just repeat the definition of a subcommittee?
A subcommittee is generally a smaller, is basically a subset of a parent public body. So I'm just trying to see, like, what does the actual definition say? Generally, it's a multi-member body created to advise or make recommendations to a public body. So generally what happens is you have, a 5-member school committee, and during the meeting they appoint, say, 2 members to a separate committee, which we would consider a subcommittee, to perform a task and then report back to the whole school committee at another meeting. Those 2 individuals would be considered a subcommittee on their own, and anytime they got together, they would need to follow the requirements of the open meeting law. So the final piece here that would not be considered deliberation is discussion of the recess or continuance of a town meeting in the event of a weather-related or public safety emergency. So deliberation by a public body with respect to any matter within the body's jurisdiction is considered a meeting.
Could you talk a little bit about the challenge of social media and deliberation? There's a lot of confusion about that in general with a lot of people about Facebook, Twitter, Instagram, but also blogging in general, and when that goes into deliberation and when it doesn't.
Yeah, I mean, basically the question is about social media. Generally what we've said is, public body members are not specifically prohibited from posting such, on Facebook or Twitter, and what we really look to is the intent of that public body member when they're posting, because if their intention is just to post for everyone to see without really focusing their comment to another public body member, then we've said that it's not deliberation, even though other public body members might be part of that Facebook group. So, if you think about it as if you're standing outside of town hall and you're just voicing your opinion and you're not really directing it to any one particular individual, but it could be heard by anyone who walks by, that's sort of what we look at in terms of what are you doing on Facebook. Are you just posting so that anyone could see it? And, maybe some other public body members are also members of that Facebook group, but you're not directing your comments to any particular member. So that might not be deliberation. We realize this is kind of a tricky area, and every case rests on its own facts and circumstances. So every case is not going to be the same. There's not just like really one general rule that covers it. We just, try and provide the best guidance that we can. It might be a difference between an open Facebook page and a closed Facebook page, because if you're posting to a closed Facebook page that only has a certain individuals that can be part of it, and if there is a quorum of members or all of your one public body are on this closed Facebook page, then I think it's a closer call, and maybe you are directing your comments to a quorum of members because it's not open for everyone to see. Blogs and other kind of listservs, the answer is always going to be like, it depends. It depends on what you're saying. It depends on who you're saying it to, if you're saying it to anyone in particular. But listservs sometimes can be a little more problematic because generally people sign up to be on those, and so the intention of posting might be more directed to public body members. So the same with email, we realize that it can be difficult to decide where to draw the line, and so we just want to caution you as to some of the concerns and really think about what you're doing and what you're saying when you're doing it to these social media websites or pages. Yes.
Maybe I'm jumping ahead, but you've mentioned there were certain liabilities if open meeting law was violated. For instance, if a person does something like that on a blog is it only gonna be a problem if somebody comes after them for violating some law, if there's a lawsuit involved? I mean, who's policing all this?
Yeah, I mean, generally, you know, in order to find an open meeting law violation, a complaint has to be filed with us first. And, you know, we'll get into that in the second
Okay,
half.
thank you, that's all.
But generally, yeah, it has to be, you know, it has to be, we'll get into like how the complaint
Okay.
process is. So that's coming up. So, deliberation and meeting, so anytime there is deliberation, it has to occur in a properly posted open meeting. Now, there are certain exclusions to what a meeting is. And those include on-site inspections. So technically, an on-site inspection under the law is not considered a meeting that you would be required to post notice for and keep minutes. But just to caution you that there can't be any deliberation at an on-site inspection. So if, for example, you're a member of a school committee and you're going to tour the grounds for a new school, or, you know, maybe a new school before it opens, you can basically go to the site, walk around, and that's it. You can't really ask questions, you can't have any discussions about the site. You would then have to go back to a properly posted meeting to have any further discussions. And we realize that this is very limiting and probably not practical. But, you know, our job is to advise you of what the law is, and there is some case law that suggests that even questions and answers back and forth between a quorum can be considered deliberation. So that's why we caution you about what happens at an on-site inspection. If you do want to, you know, ask questions and get more information, what we would recommend is that you either post it as a meeting, which I realize sometimes is also not practical, or you send less than a quorum. And that way, if you send less than a quorum, technically it might not be a meeting under the open meeting law, which would require you to post notice. One of the other exclusions is the attendance by a quorum at an event. So if you're like, you know, if you're having a Christmas party coming up and all the members want to attend, we would consider that to be an event that is not subject to the open meeting law. That's not a meeting as defined under the law. You know, just don't discuss with each other. If you do see other members there, don't discuss committee business. So you shouldn't be, you know, standing in a corner huddle talking about board business at like a holiday party. You can attend a meeting of another public body. So just because you're a member of one public body doesn't mean you lose your rights as a citizen of another public body, or lose your rights as a citizen to attend a meeting of another public body. You know, what we would just caution you about is if you are attending the meeting, you know, you are going as a citizen of the community, which means you participate as any other citizen would. You don't have any greater rights of participation or access just because you are a member of a public body. It's probably best not to sit with other members. If you do see other members there, don't sit together. And then, you know, you likely shouldn't be speaking as a public body member, especially if other members of your committee are also in the room. You know, if you want to do that, it might be worth just having a joint meeting. So meetings of a quasi-judicial board for the sole purpose of making a decision in an adjudicatory proceeding, that only applies to state public bodies. So if you are a state public body member, you probably know about this exception anyway. And then town meetings are excluded from the open meeting law. So we don't have the authority or the jurisdiction to review any issues or potential issues that come up by public body members at a town meeting. So notices have to be posted for every meeting. And except in an emergency, those notices have to be posted 48 hours prior to the meeting. And that 48 hours excludes Saturdays, Sundays, and legal holidays. The notices have to include the date of the meeting, the time of the meeting, the place of the meeting, and a list of topics that the chair reasonably anticipates will be discussed. So basically you want to list topics with enough information so that someone who's thinking about attending the meeting could read that topic and understand generally what will be discussed at the meeting. You know, usually we've said general topics such as old business and new business on their own are not sufficient, but you could use them as headers under which more specific topics could be listed. You can discuss a topic that is not listed on the notice if that topic arises unexpectedly within the 48-hour period prior to the meeting. So if a topic arises that was not reasonably anticipated by the chair before the meeting notice was posted, technically you can discuss that topic at a meeting. You know, we recommend that you revise your notice to include that topic. And then just remember that all notices have to include the date and time that it was posted. And if you are revising your notice, you have to include the date and time that the notice was revised, as well as the date and time that the original notice was posted. And that just ensures that you are complying with the open meeting law, and if there's any question, there's a record of when you posted, if you are including a topic that wasn't previously there. Yes.
If a quorum of a board learns about a meeting that they're interested in within the 48 hours and they plan on attending, is there any option to post them at that meeting where you're within the window and it was not reasonably expected that they would be attending prior to the 48 hours?
I don't think so. I mean, that, you know, that sort of section really talks about amending a notice to include a topic. It doesn't really cover just posting a meeting in general.
So would that meeting not be an option for them?
I would say, yeah, that meeting would not be an option. So either they don't send a quorum, or I mean, if they simply want to attend just to hear and they're not going to participate as a quorum of their own board, then it might not be a meeting, simply because they're not participating and they're not speaking and they're not discussing board business. But if they want to attend as a committee and speak as a committee at another meeting, I think they have to post 48 hours. And it would not be an emergency, which is when you don't have to post a meeting. So, I don't think that would be possible. What an emergency is considered is a sudden, generally unexpected occurrence or set of circumstances that demands immediate action. So generally these include issues about public health or public safety. It's not going to be like a forgotten scheduling item or some kind of conflict where you've realized that you're not going to have a quorum, or all of a sudden you need to discuss an issue before a deadline. Those are not the types of issues that we consider to be an emergency. Generally, if it is a true emergency, you're still required to post notice. It's just not 48 hours notice. So whenever you learn that you do have to meet in an emergency fashion, post notice as soon as you can. So where do you post notice? If you are a local public body, you file with the municipal clerk, and then you file to a place that is available basically 24/7. Because notices have to be posted in a manner that is conspicuously visible to the public at all hours. So it's either to a bulletin board that might be outside of town hall that anyone can access 24/7, or you choose the website. So if you adopt the website, or if you want to adopt the website, for local public bodies, the language of the law is the chief executive officer makes that adoption. So for local public bodies, it's generally the Board of Selectmen. In the city or town, it might be the mayor. He or she or they as a board would adopt the website, and then once it's adopted, that is the official posting location for all notices. So if you do adopt the website, we ask that you just notify our office that you've done so, what the actual website address is, because we do keep a list. If anyone wants to look up notices, we do have a list. There also should be sort of some kind of information posted in or near the clerk's office about what the website is. So outside of the clerk's office somewhere that people can find, there should be a notice of where all notices are posted. If you are posting to a website, you do still have to provide a copy to the clerk, and he or she posts that notice in or around town hall, so that anyone who comes in to town hall during regular business hours can see the notices that are posted. Now, if you are any other type of public body, regional or district public bodies post notice in each city or town of which they are a member, or they post to a website. For a regional school district, the secretary of the school district is the clerk for that district and files in each city or town in which that school is a member of, or they post to a website. For county public bodies, they post notice with the Office of the County Commissioner, or they post to a website. For state public bodies, all state public bodies have to post to a website. So they either post to their own website, or they post to their parent agency's website. Again, we ask you to notify us what the website is that you're posting to. We do not need to receive a copy of the notice for state public bodies, but you are required to file a notice with the Regulations Division at the Secretary of the Commonwealth's office. Now, we do get some sort of commonly asked questions about notices. And one of those is, what if a new topic arises after the notice is posted? So we certainly encourage you to post notice as close to the 48-hour time as you can, and hopefully that will eliminate a lot of changes that you would make to your notice. We don't want to see you post so far in advance that you always consistently have to make changes to the notice itself. So if you do have a new topic that arises and it was unanticipated, like I said before, you can revise your notice to include that topic. What if the clerk can't post notice in time? So, the responsibility for posting notice is with the public body, not with the clerk. So we encourage you to work with your clerks to make sure you know if there's a specific time frame or a specific time that you need to get the notice to them so that it can be properly posted, that you find that out, that you make sure you're aware of their hours or any days that they may close early, so that you make sure you get the notice to them if they are the ones posting the notice for you. Because if it wasn't posted in time, the responsibility falls to the public body, and they will be the ones considered to be in violation of the law if the notice was not properly posted, not the clerk. We consider notices to be properly posted when they're published. So when they're published to a website, for example, not when they've been received by the clerk. So if you send the notice to the clerk at 4:59, but it doesn't get posted to the next day, it's considered properly posted when it's on the website, not when you send it to the clerk at 4:59. So just keep that in mind if you're, when you're considering the 48-hour time period. Canceling a meeting, there's no specific requirement under the law that you post notice if you're going to cancel a meeting. We certainly, if you can, best practice, and it's certainly recommended that you send some kind of notice or some kind of indication that a meeting is being canceled, but there is no specific requirement that you post a separate notice if you're going to cancel a meeting. Just remember that if you're going to be continuing a meeting, that continued meeting still has to follow the 48-hour requirement. So if you're meeting on one night and the meeting is going late till 10 or 11 o'clock at night, and you decide you just can't get through the rest of the business and you're going to continue the meeting the next night, you can continue if you properly posted 48 hours prior for the next day. If you did not, then you can't just carry over the business to the next day. So just to keep that in mind. Also keep in mind that there might be other posting requirements if you're holding a public hearing. There might be additional requirements that you need to follow, such as posting in a newspaper or perhaps even posting for a longer period of time for public hearings that might be separate and distinct from the open meeting law requirements itself. Was there a question?
Yeah, and it was to that point. How do you find out what topics need X amount of time on posting public hearings?
For public hearings, just because it's outside of our jurisdiction, for public hearings, technically it's still considered an open meeting because a quorum of a public body is there discussing board business. So at the very least, you have to follow the 48-hour requirement for the open meeting law and, list the topics and the hearings that are going to be heard that night. Unfortunately, anything beyond that is outside of our jurisdiction, and so we usually tell you to reach out to your town legal counsel for additional guidance on public hearings. So, if you're posting to a website, we certainly just recommend that notices should be easy to find, maybe on a central page. We just want them to be, to someone to be able to find them so they don't have to click around several times in order to find the notices. If you can avoid posting in multiple locations, that's certainly best practice, unless everything is kind of linked together. And, this really hasn't come up too much, but we thought, if you're posting to a website, what if the website goes down? What should be the requirements or the obligations of the public body then if the website crashes for some reason? Because notices have to be posted or have to be available at all times. And so basically what we've tried to come up with is that if a website becomes unavailable, the website has to be restored within 6 business hours of the discovery. So if the website, for example, goes down at 2 in the morning, but the clerk doesn't, open the office until 9, and that's when he has discovered that the website has gone down. The 6 hours would start from 9 a.m., not 2 a.m. when it actually crashed. It would start from the discovery. So you have 6 hours from the discovery to fix the website. If you cannot fix the website, then the meeting has to be canceled and you would have to repost for 48 hours. I don't think this has really come up. We certainly haven't addressed this issue before, so hopefully everything is working. As a reminder, meetings have to be accessible to all persons, and that includes persons with disabilities. So meetings people have to be able to get to the meeting. They have to be able to see and hear what is happening as well. So just a reminder, if you have any concerns about whether or not your meeting is accessible to those with disabilities, if you have a Civil Rights Commission or Civil Rights Division, this is their contact information, so if you have any questions, feel free to give them a call to see, if you have questions about whether you're in compliance with any federal rules. You can meet in buildings that require identification. So just because in order to enter a building, you might be required to provide identification, that doesn't mean you can't hold a meeting in that building. Best practice is to list on the notice some indication that if you are interested in coming to the meeting, entry to the building requires identification. So that would be the best thing to do to put on the notice. We hope that you're not using or you're not meeting in a building that requires identification to exclude certain individuals. So that shouldn't be your goal in meeting in a building that requires identification to exclude certain individuals from entering. Now, yes?
Could you please comment on what happens if you post a meeting for a specific room, like a conference room, and then it turns out you have a crowd 3 times the size and you move it around the corner to the library, what, is that allowed? What, do you
Yeah,
put
so
hang up
if-
signs or anything?
Yeah, if you are meeting in a location, in one location, and then at the meeting, you know, a crowd that you didn't reasonably anticipate to arrive is there, yeah, it's fine to move to a different location that will accommodate the number of people that are there. So generally, you want to be choosing a room that will accommodate the number of people that you reasonably anticipate will be present, but sometimes that expectation, you know, is above and beyond what you thought. So you can certainly move to a different room. What we've recommended is that, yes, you post some kind of signage directing people to that area, or you at least leave a person outside the room, something that will tell people, you know, how to get to the new location. Yes.
Clarification. I think the gentleman's question referred to going to the library, different building. So you're saying that if you change to a room within the building, you're okay, but if you change to a different physical address,
No, we have said that you can change to a different physical address as well. So I had a situation, a complaint was filed where the meeting was in one building. It was realized the day of the meeting that a large number of people were going to attend, and they moved it down the street. And so we found in that situation, because the clerk or the chair of the commission, you know, revised the notice, contacted all the board members, and had a big sign outside the building to indicate that the meeting location was at a different place down the street, that was fine and complied with the open meeting law. So just as much information as you can get out there if you are going to move a meeting. But again, you know, like every case, it's going to rest on its own facts and circumstances. But we did find in that situation, because of all the advance notice, that moving to a new location was fine. So the Attorney General's office has approved the use of remote participation, but before you can use it, it has to be approved first. So for local public bodies, again, it's the chief executive officer, which for a town would be the board of selectmen, and then for the city would be a mayor. So once they have approved it, it's approved for all public bodies to use. For county public bodies, it's going to be county commissioners, and on the state or regional level, it's just a simple majority vote that would authorize the use of remote participation. The only exception is commissions on disability. They just need a simple majority vote of the commission to approve the use of remote participation. So if remote participation has been approved and you want to, if a member wants to participate remotely, physical attendance at the meeting has to be unreasonably difficult. And generally we see this is because you're out of state or in another location and you simply can't attend that meeting. If someone is going to be participating remotely, then all persons who are present at the meeting location must be clearly audible to one another. A quorum of the public body has to be present in the physical location of the meeting before anyone can participate remotely. So you have to have a quorum already present in the meeting location before someone can participate remotely. Members of the public body who do participate remotely can vote. They're not deemed absent from that meeting. So there are certain procedures for participating remotely. First, the individual who wants to participate has to notify the chair. During the meeting, the chair has to make an announcement of which member is participating remotely. All votes during the meeting where there is a remote participant have to be done by roll call. If the public body is going to meet in executive session, the person who is participating remotely just has to make an announcement that no one else is present in his or her location. And then if you can, it's advisable to provide documents ahead of time to the individual who is going to be participating remotely, since they won't be at the meeting to receive those documents. So there are certain acceptable methods for remote participation. Telephone, internet, satellite, basically anything that enables the remote participant to hear each other. They don't necessarily have to see each other, but at least to hear each other. So texting is one form that would not be accessible for remote participation. The public body decides which type of technology to use. If a member is going to be participating remotely, and if you're going to be using any type of video technology, the remote participant has to be clearly visible to people who are at the meeting. So the remote participant doesn't have to see everyone, but everyone has to be able to see the remote participant. If technical difficulties arise, the chair determines how best to deal with that situation, whether you take a short recess or whether you just end that meeting with the remote participant. If there are technical difficulties that arise and the remote participant is lost, there should be some kind of notation in the minutes about that particular incident. And then finally, for my piece of the presentation is this public participation. So again, all members of, yes,
I have a question about the chair
yeah,
for remote participation.
Okay.
So if the chair is absent and he wants to, or she wants to participate remotely, and there is no vice chair and there's no acting chair, how can that be performed when there has to be an acting chair in order to have the meeting physically?
so someone has to be designated. Basically what the law says is that the chair, or in the chair's absence, the person authorized to chair the meeting has to be present.
So that should be made known prior to this
That
type
would
of...
be helpful,
Uh,
sure. But yeah, someone has, if the chair is not present, if the chair is the one participating remotely, there has to be someone else who's given the authority for that meeting to act as the chair.
So if that's not the case and there isn't a person designated, then that meeting cannot happen.
Yeah, I mean, we've never had that specific issue, but I would say, yes, no one, then there shouldn't be, I mean, the meeting can proceed, but I guess the remote participant couldn't participate.
Thank you.
Another question with remote?
Yeah, sometimes a meeting's going on and one person's going to be missing because they're out of state, but then you've had a meeting that's needs to be held for an important topic, and a second member is caught up at work and can't get there right away, but may participate because he's working in Boston. Are you limited to the number of remote participants?
You are not, as long as a quorum is physically present in the meeting location.
Right.
So if you have a 5-member board, technically you could have 2 members participating remotely, but you couldn't have more than 2 because you'd have to have 3
Right.
in the meeting location. So finally, public participation. Public always has a right to attend any open session meeting. They actually do not have a right to participate in that meeting or speak at the meeting unless they've been authorized by the chair to do so. The individual does have a right to make an audio or video recording of the meeting, so they cannot be told that they can't make a recording. They have the absolute right to make any recording. What the chair can do is suggest placement of equipment so that it doesn't interfere with the meeting itself. I assume most people are recording on their phones now, so just sitting in a chair and recording the meeting is generally not going to interfere. But if they have an actual handheld equipment that needs to be placed somewhere, the chair can recommend placement so that it doesn't interfere with the meeting. If the individual wants to record, they are supposed to tell the chair, advise the chair that they are recording the meeting, because the chair has an obligation to make an announcement at the beginning of the meeting that the meeting is being recorded. And then finally, if an individual starts to disrupt a meeting, they have to be given a warning first. If they continue to disrupt the meeting after being warned, they can be removed from the meeting. Does anyone have any questions? That's the end of the first part of the presentation. Does anyone have any questions on?
Yeah, so it is about the minutes.
Yes.
Said that minutes must be kept, but does it mean that they should be posted or just be kept somewhere?
So I think Carrie's going to get to that, because what's required in terms of what needs to be in meeting minutes and all of that is in the next part of the presentation. So I think we're going to cover that. Yes.
I have one question. If town hall is closed on a Friday and that would normally be a legal posting day. They can't send the posting when nobody's there and have that count, correct?
Correct. If all notices are posted by the clerk and the clerk's office is closed on Friday, technically they lose that day. So that's why we certainly recommend that any public body members are aware of clerk's offices, because if you have to provide the notice and the clerk is responsible for posting, then technically, even though that counts as a business day, you would lose it because there's no one there to post it for. So they should be getting it to you like Thursday. Yeah.
Okay. What if somebody is in the office and can post it?
I guess that's within your discretion, like if you want to be nice and post it.
I'm nice,
I mean,
I like to post it.
yeah, but I guess if you're there just because you want to catch up, but technically you're not, like that's not a paid day for you, and the office is closed, then people should just be aware of that. But I guess it's within your discretion, because if you keep doing it, that people are going to get in the habit that, oh, so and so is always there, she'll post it.
No, I'm nice, not that nice.
And maybe one day you're not there. So I guess I just leave that to your discretion to decide if you want to do that or not. Sure.
All right, 7th inning stretch. So again, my name is Carrie, and I'm going to present the remainder of the program. We have 3 main topics that we're going to cover for the remainder of the evening. So we're going to talk about executive session, we're going to talk about the requirements for meeting minutes, and then we're going to talk about the open meeting law complaint process. So we've had some great questions. Again, if people have questions about clarification issues as I go through, feel free to raise your hand. Otherwise, the 2 of us will both stick around at the end, and we're happy to take questions that relate more to particular individual situations. So, executive session. Oh, it was working until a minute ago.
Yeah.
Carrie, am I doing something wrong?
You just kind of have to really point it at the computer.
There we go. All right. Okay, so executive session. In just a moment, I'm going to talk about the permissible uses for executive session. The most important thing for you to know is that in the open meeting law, there are 10 and only 10 permissible purposes for holding a discussion in executive session. We will go through in detail what those 10 permissible purposes for executive session are. There are no additional executive session purposes. There are no implied executive session purposes. So only discussions that fit within one of the 10 enumerated executive session purposes can be held in executive session. So let's say you have a proper topic to discuss in executive session. How do you do it? Let's talk about that. So the first thing that needs to happen is that the meeting needs to be convened in open session. So if the only item that you have on your agenda for the evening is an executive session discussion, then you first need to call the meeting to order in open session. The public has the right to be there. They have the right to come, even if it's just for a few minutes, to witness the procedural steps that we're going to talk about. So the meeting is opened in open session. Then the chair of the public body, unless the chair specifically designates somebody else, the chair of the public body needs to state the purpose for the executive session discussion and needs to identify or state all information about the topic to be discussed that can be provided without compromising the lawful purpose for the executive session. So it should include enough information to identify the nature of the discussion as well as which of the 10 executive session purposes the discussion is authorized under. Then there needs to be a roll call vote taken of the members of the public body. And so related to this point, we often get questions, what if a topic is on a meeting notice for executive session, but then the public body decides to have the discussion in open session, maybe because they decide that they just want to do it in open session, or maybe the vote fails. A topic that is properly included on a meeting notice for executive session can be discussed in open session. If it was anticipated for executive session and there is some kind of a change, it can still go ahead in open session, again, because this step of taking a vote is always a necessary first step before an executive session can proceed. So it is always possible that that vote can fail and that the discussion can then proceed in open session. The chair also then needs to make an announcement as to whether the meeting is going to reconvene in open session afterwards or whether the public body is going to conclude the meeting and adjourn directly from executive session. If there are any remote participants, then any remote participants need to state that there is nobody else present at the remote, the remote location who can see or hear the executive session discussions. And then, now that the public body is in executive session, any votes that are taken during executive session need to be conducted by roll call. So that means, I'm sure you all know what it means to take a vote by roll call, but we see violations on this issue with some frequency. The meeting minutes themselves need to reflect the roll call vote. So that means that each person's vote, even if it's unanimous, each person's vote, after having been taken by roll call, should also be inserted in the meeting minutes individually. So now we're going to talk about the 10 executive session purposes. The first executive session purpose is to discuss the reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss the discipline or dismissal of, or complaints or charges brought against public officers, employees, staff members, or individuals. So, yes,
I'm
question?
sorry to interrupt. If you have back-to-back executive sessions, would the board vote to go into all three of them as one vote? Because technically, once they've voted to go into executive session, they can't then vote to go into an executive session because they're already in it.
Right, so if there are, let's say, 3 different topics and they fall within 3 different executive session purposes, or maybe they all fall within the same executive session purpose, all of those topics should be described in the chair's statement. And the chair can state, we're going into executive session to discuss topic A in accordance with purpose 2, and to discuss topic B in accordance with also purpose 2, and then discuss topic C in accordance with purpose 7, something like that. But as long as all of the information that needs to be provided is included in the chair's statement, then there can just be one vote, and then the executive session can proceed, and all of those topics can be discussed. So purpose 1 applies to a few different situations. One thing that I will mention is that we have interpreted this purpose as allowing a public body to discuss open meeting law complaints in executive session under purpose 1, because an open meeting law complaint is, by its very nature, a complaint against public officers. So when we talk about the complaint process, you can keep this executive session purpose in mind. And then again, generally to discuss reputation, character, discipline, complaints. Now, when a discussion is being had in executive session under Purpose 1, there's something that's somewhat unique about Purpose 1, which is that the subject of the executive session discussion under Purpose 1 has the right to be notified in writing 48 hours in advance of the meeting, and has the right to attend the meeting. And along with that, has the right to have counsel present, to speak on his or her behalf, to have a recording or a transcription made of the executive session. So this is unique and is not required under any of the other executive session purposes. So the person who is the subject of this discussion always has that right and must be notified in advance. The person does not have to decide to show up, and if they don't show up, then the discussion can still proceed. But they do need to be notified and given those rights that I just mentioned and that are listed in the materials. Now, it's also notable here that there's this exclusion rather than professional competence. So discussions generally about professional competence of an employee, of an official, need to be had in open session. Those types of discussions are not appropriate for executive session. So sometimes you have, for example, a board of selectmen that might be conducting their annual review of the town administrator. The general review, the discussion of professional competence, the performance evaluation, needs to be done in open session. If there are particular complaints against that individual, those complaints can be discussed in executive session, but again, that's provided that the individual was given notice and given the opportunity to be present for those discussions. Executive session purpose 2 is to discuss strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. And so when having a discussion under executive session purpose 2, there's a presumption that this discussion of professional competence of the individual has already happened in open session previously, but then you can take the results of that review of the person's professional competence and have a discussion about, let's say based on our performance review and our evaluation of this person's work over the last year, we think this person merits such and such percent raise. That type of discussion can happen in executive session, but again, the performance review type of discussion needs to happen in open session. When negotiating a non-union contract in executive session, if the public body reaches an agreement, then it can reach agreement on terms in executive session, but then it needs to return to open session and have the final vote to approve the terms that were reached and have that vote in open session. And then when providing information on the meeting notice, as well as in the statement of the chair prior to entering executive session, that information should include, because you always need to include as much detail as possible, that information generally needs to identify the specific non-union personnel who is going to be the subject of this discussion.
Just a quick question.
Yeah.
Is it okay to do a performance review in an open session?
Yes, performance reviews generally need to be done in open session.
Okay, so almost all, okay, all right.
All right, so executive session purpose 3 is to discuss strategy with respect to collective bargaining or litigation, but then there's this important caveat, the second portion of this sentence: if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. So this executive session purpose is specifically to have strategy types of discussions. So if there is a litigation matter, and let's say town council just wants to provide a general update, but there's not really a discussion of strategy, it's just here's the status of litigation, that type of discussion would not fall within this executive session purpose. This really is limited to discussions of strategy related to collective bargaining or litigation. And again, when providing notice of the topic and in the chair's statement prior to convening an executive session, to be sufficiently detailed, the specific bargaining unit that is involved or the specific litigation matter generally needs to be identified. The one exception that we see sometimes is that when a public body itself is considering bringing litigation and it's talking about strategy related to litigation that it has not yet initiated, then it may not have to provide information about the anticipated litigation, because doing so could harm its litigating position and might tip off the individual or company that it is considering bringing a lawsuit against. But in general, there needs to be some identification of what the specific bargaining matter or litigation matter is about. Executive session purposes 4 and 5 are more limited. We don't see them used as often. But purpose 4 is kind of your post 9/11 discussions of security personnel or devices. So a discussion about where police officers are going to be stationed along a parade route, or where security cameras are going to be mounted. Those types of discussions can be had in executive session under purpose 4. Discussions of criminal misconduct. In particular, let's say a board of selectmen is deciding whether to pursue charges related to a situation that occurred. Those types of discussions can occur in executive session under purpose 5. Purpose 6 is one where we see a lot of confusion, so I'm going to spend a few minutes here. Purpose 6 is to consider the purchase, exchange, lease, or value of real property. And then again, this purpose has that same caveat that was that we found in purpose 3 for litigation strategy. It's if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. So purpose 6 is related to discussions, or it's for discussions that relate to real estate transactions. So not just, we have this parcel of land, what should we use it for, but more of, we're thinking about buying this parcel of land. What's it worth to us? How much are we willing to pay? If we pay this much, then we can't offer as much on this other parcel of land that we're also interested in for conservation purposes. So it really needs to be a discussion related to where the discussion would could impact the negotiating position of the public body as it relates to a real estate transaction. And then generally, we have said that once that real estate transaction is concluded, so let's say a parcel of land has been purchased, then future discussions related to that parcel generally would not be appropriate for executive session under Purpose 6. All right. Executive session Purpose 7 is a little bit more general, and it is to comply with or act under the authority of any general or special law or federal grant in aid requirement. And so what this means is that there is some other law that requires confidentiality, and so there is a need to have a particular discussion in executive session in order to comply with that other law. This could come up in the context of a school committee that is discussing matters of student privacy, and so you have federal student privacy laws that might require a discussion to be had outside of public view. Applications for tax abatements are required by state law to be kept confidential, and so those types of discussions would fall within this purpose, Purpose 7, and this would be the purpose that you would cite to, usually also identifying what the other law is that allows the discussion to be had in confidence. Executive session Purpose 8 is the preliminary screening committee purpose. So this executive session purpose allows public bodies to go through the hiring process and retain the confidential nature of applications and job applicants. So sometimes if you have people applying for a position, let's say it's a town library director, people might expect that there will be some privacy in their applications, at least until they reach a finalist stage of the process. And so what can be done is that a public body can identify a preliminary screening committee. And a preliminary screening committee has several of its own requirements. So first of all, a preliminary screening committee needs to consist of fewer than a quorum of the public body that will be making the ultimate hiring decision. And that makes sense because if you have a quorum of the public body on the preliminary screening committee, then they have essentially already made their decision. So you have to have less than a quorum of the ultimate decision-making body on the preliminary screening committee. And then the preliminary screening committee can meet, they can review resumes, they can do early stages of interviews, they can narrow the pool of candidates, but then they need to forward more than one finalist to the decision-making public body. And again, that's necessary because if the preliminary screening committee is meeting in executive session under Purpose 8, and they're doing all of this outside of public view, then it's important that in order to preserve the ability of the final decision-making body to actually make the final decision, they need to have more than one person in front of them. So the preliminary screening committee needs to forward more than one finalist, and then the final round, so the final round of interviews, the final decision-making, needs to occur in public. So that would not fall under executive session Purpose 8. Again, Purpose 8 is limited to preliminary screening committees and those preliminary stages of review. And then executive session purposes 9 and 10 are also ones that we see less commonly. Purpose 9 is to confer with a mediator on litigation or some other decision. And then Purpose 10 is very particular, related to trade secrets in the course of activities conducted by a public body as an energy supplier. And you probably will know already if that applies to you. So any questions about executive session before I move on to meeting minutes? All right, so moving on to meeting minutes. Meeting minutes are so important because we recognize that a very large number of people are very interested in the business that occurs and that the actions that are taken by their representatives, and yet they're not able to attend every meeting. And so there are various requirements both for the process surrounding meeting minutes as well as for the content of meeting minutes, and we're going to take some time to talk through meeting minutes here. So meeting minutes need to include, at a minimum, the date, time, and place of the meeting, and a list of the members who were present or absent at the meeting. So that is fairly straightforward so far. Then minutes also need to include a summary of the discussion that was had on each topic, decisions that were made and actions taken, and a record of all votes. So let's talk about the level of detail that is required for meeting minutes, because this is, I would say, one of the more common areas where we see open meeting law complaints. And there is not a clear formula that we can give you for how much detail you have to have in the meeting minutes. Meeting minutes do not need to be a transcript. In fact, they should not be a transcript because the law requires that minutes reflect a summary of the discussions. But they also do not need to include every comment, every opinion. We do say, though, that there needs to be enough detail in meeting minutes that a member of the public who wasn't at the meeting could read the minutes and have a general sense of how the discussion went. And so when we see minutes that just say there was a discussion about, and then the topic as it was listed on the meeting notice, that really doesn't tell us or a member of the public anything other than that the topic that was on the notice was in fact discussed. So there needs to be some more substance. We generally advise that the predominant opinions that were expressed should be captured in the minutes. If there was kind of a majority view and then a dissenting view, then that should also be explained and captured in the meeting minutes. It's not necessary to identify in detail which members of the public body were on one side and which members were on the other side. Certainly that is fine to include and it might be helpful, but the most important thing is that a general synopsis of the discussion is included, something more than just there was a discussion about X, Y, and Z. And then again, a record of all votes need to be taken. And then the meeting minutes need to include a list of any documents and exhibits that were used by the public body at the meeting. So we get a lot of questions about when is a document considered used. What if you just have one member who brought something with them and they kind of had it in their personal stack of paper, but it wasn't actually distributed. So we say that a document is considered used at a meeting when the document is physically present, verbally identified, and its content is discussed. So, for example, sometimes you have a member of the public who sent a letter to the public body in advance. If that letter is present and is actually read and then discussed, then that's a document used. But if the chair just brought the letter and said, and we received some correspondence from 3 people who are opposed to the project, and then they moved on, then those might not be documents that were discussed at the meeting. So it really depends on how they were discussed, whether they were identified or whether they were simply physically present but not really discussed at any level. Yes?
Can I ask you a question about exhibits?
Sure.
Sometimes at meetings you'll have a diagram of a product, aerial photographs, things like that are put on an easel, they're identified by name, they're physically present, and they're discussed. Whether they're brought forth by the board holding the meeting or by a presenter or the member of the public, is that something that the board has an obligation to retain under the concept of documents used in the meeting?
So that's a really good question. And so the open meeting law does not require that documents and exhibits used at a meeting be maintained with the meeting minutes. They just require that the items be listed with in the meeting minutes. However, you should be aware of separate record retention laws, and those types of items might be subject to records retention laws, which is outside the scope of the open meeting law, but certainly very related. And those types of items might be required to be maintained in accordance with those separate laws. So if you have questions about, for those types of things, how you would go about maintaining them, the supervisor of records in the Secretary of the Commonwealth's office can provide more guidance on records retention. But for open meeting law purposes, you just need to list the documents.
One question, remote participant. So do we need to specifically mention that this person is remote?
It's a good idea to identify that there were remote participants. The law, I don't believe, specifically requires that the minutes identify that. But certainly it's a good practice when identifying members who were present or absent to list anybody who was present. And then keep in mind, as I believe Carrie mentioned earlier, but if you do have a remote participant, even just one remote participant, every vote that's taken at that meeting needs to be taken by roll call and recorded in the meeting minutes, again, person by person. There was a question earlier about posting meeting minutes. So minutes need to be, we're going to talk about approval. Oh. Okay, so approving meeting minutes. Meeting minutes, after they're created, need to be approved. And the timeline for approving meeting minutes is that meeting minutes need to be approved at the later of the next 3 meetings or 30 days. So for a public body that meets every week, they can take advantage of the full 30 days. For a public body that meets less often, they have until their 3rd meeting thereafter. For some public bodies that meet very infrequently, we recognize that it could be many, many months before they have 3 more meetings. We do recommend that minutes be approved at the next meeting whenever possible, again, just to expedite the public's access to those records. Then there also is a requirement that meeting minutes be provided upon request. So there is no requirement in the open meeting law that meeting minutes be posted online once approved. The public records law has a separate requirement that certain types of frequently requested documents, and I think they call out meeting minutes, should be posted online, but the open meeting law does not require that meeting minutes be posted online. It just requires that they be approved in a timely manner and then made available upon request. So if there is a request to a public body for meeting minutes, the public body has an obligation to respond within 10 days, and this is 10 calendar days. So it's not 10 business days, which the open meeting law, or which the public records law allows for public records requests. It's a little bit confusing because it's a shorter time frame, but 10 calendar days to respond to a request under the open meeting law for meeting minutes. And then the minutes need to be provided, if they exist, whether they're in draft or approved form. So if somebody makes a request the day after a meeting for the meeting minutes, and the meeting minutes, have been drafted, but they're not going to be approved until the next meeting a month later, there is still an obligation to provide those draft minutes, and they can be provided, and it can say draft across the minutes in big gray letters. But the open meeting law does require that minutes be provided if they have been drafted, even if they have not yet been approved.
Now, if somebody requests minutes and you get in touch with them and let them know, I only have draft minutes available, would you like to wait until we have approved minutes and I can send them to you? And they put in writing that they will wait for the approved minutes, are you still obliged to get them draft minutes within the 10 days?
I don't think that we, in that situation, that we would say that you violated the law if you didn't give it to them, if they specifically agreed to wait.
One question.
Yes.
So minutes they are not posted. Where do you store them? On the individual machines? Where do you post?
So usually minutes are in the clerk's office. That really just depends on the public body. So some public bodies completely take upon themselves the task of preparing their own meeting minutes. They keep their own meeting minutes. Sometimes public bodies have administrative support through the clerk's office or otherwise. So that really depends. The open meeting law doesn't specify where the meeting minutes need to be maintained, as long as they are made available and can be made available upon request within 10 days. Now, executive session minutes have some additional requirements. So executive session minutes need to be prepared and approved in a timely manner, just like open session minutes. And they need to be just as detailed as open session minutes do. So all the requirements that we just talked about for what needs to be in the minutes, level of detail, timely approval, that all applies to executive session minutes as well. However, executive session minutes are not automatically released to the public until the public body determines that the lawful purpose for the executive session has expired, such that the minutes can then be produced and won't compromise whatever the initial lawful purpose was for the executive session. So how does this happen in practice? What needs to happen is that a public body must periodically review all of its executive session minutes to determine whether the purpose for the executive session has expired. So we have recommended we have said that it's acceptable to do that every 3 months or every 6 months. Any longer than that probably is not sufficient to be considered a periodic review. But we would recommend on a quarterly basis or semi-annual basis to review all outstanding executive session minutes to determine whether the purpose for the executive session has expired. The public body can do that review as a body if it wants to. It can delegate the task to one person, to legal counsel, really to anybody else. After that periodic review is done, then at the following meeting of the public body, there needs to be an announcement of which meetings were reviewed and what the outcome was. So either that they were determined to be released to the public, or that the executive session purpose was ongoing, and so the matter, that the minutes still cannot be released. So for example, if you have discussions of strategy related to a litigation matter, eventually, it could take 6 or 10 years, but eventually that litigation matter is going to be over. If there are discussions about strategy related to a real estate purchase, eventually that transaction is going to be over, either because the transaction happened or because it has been abandoned. So most meeting minutes eventually need to be released to the public. And so the public body has an affirmative obligation periodically to do this review of meeting minutes. And so this is an additional step to the requirement to prepare and approve minutes. Now, if a member of the public makes a request for executive session minutes, the public body still needs to respond within the same 10 calendar days that we just talked about, but the response can state that these minutes, these executive session minutes that you've requested, have not yet been approved for release. So if the minutes have not yet been reviewed for potential release, then the public body has an obligation to review the minutes either at its next meeting or within 30 days, whichever comes first, and then follow up with the requester to identify what the outcome was. So either we have determined that the executive session purpose is ongoing and we cannot give them to you at this time, or we've reviewed them and they're being released, and so here are the minutes. We have said that if the minutes were just reviewed, let's say 2 weeks ago, then it's fine to say in that initial response, we have just recently reviewed the minutes and they cannot be released at this time. But if it has been a while since the last review, then you do need to do the review again within 30 days or at the next meeting, whichever comes first. Yes?
The question, is it necessary to review those minutes in an executive session to avoid the risk of having them become public record?
So that's a good question. The way that the minutes are reviewed really is up to the public body. So sometimes that's why if a single individual is delegated the task of reviewing, then that's not an issue at all. They can just do it on their own outside of the meeting. If the minutes are going to be reviewed in executive session, then that would be fine. And we would say that the executive session purpose that you cite to for reviewing executive session minutes would be purpose 7. So that's the purpose that allows you to go into executive session to comply with a law. So we would say that the law that you're complying with is the open meeting law, and whatever authority there was to meet an executive session in the first place, that authority continues to give you the right to review those executive session minutes in confidence. So we certainly recognize that when you're doing that review, you want to make sure that you don't accidentally divulge the information unintentionally.
I have a question.
Yes.
So we had a similar situation, and town council instructed that we review the executive session minutes under the executive session number that we went into the executive session with in order to review. He didn't mention 7.
So I think it's kind of splitting hairs here, because what I'm saying is that you would cite to purpose 7 because the law that authorizes you to meet under purpose 7 is purpose 3. Does that make sense?
Yeah.
No,
it does.
Right. So I don't think that we have ever or would find a violation if the public body kind of accidentally cites to the wrong purpose because they cited to the one that they're relying on, rather than saying that we are citing to 7, which is based on purpose 3.
Oh, no,
So-
that's not what I was asking. They didn't
Okay.
cite 3 either. They cited the purpose for which they went into the executive session to begin with. So we went under, let's say, I'm just going to pick numbers, okay, like 6 and 4. So to review the minutes, we cited 6 and 4.
Right. So that technically, I think, would not be the correct way to do it. But again, I'm saying that we have not found a violation, and I don't think would find a violation, because what you're doing is what we're saying you're allowed to do.
Right.
It's just kind of citing to the wrong section.
Right,
Yeah.
the wrong section. Okay, thank you.
Yes.
A preliminary screening committee to do a hiring employee. Now that preliminary screening committee is dissolved because they've got finalists, now those executives, preliminary executive sessions, preliminary meetings were in executive session. then who releases those executive sessions now that that preliminary subcommittee is no longer exists? The parent body?
Yeah, so the question was, what happens when you have a preliminary screening committee, or really it could be any subcommittee that was created for a limited purpose and then they cease to exist. So we have said in general that their parent public body then takes on their obligations. So even for something as routine as reviewing minutes, every subcommittee or limited duration body will eventually have its last meeting, and we don't want them to have to keep meeting in perpetuity to review minutes. And so we've said that their parent body can then take on this obligation of approving minutes and reviewing minutes periodically for release. So that would be the appropriate way to do that. Yes, question in the back.
What about executive session minutes having to do with purpose 1?
So what happens is that once a lawful purpose for an executive session has ended, the documents, both the minutes and the documents used, would need to be released unless there is an exemption under the public records law that allows them to be withheld. And so a lot of the time you have a discussion and the open meeting law says, okay, the purpose for the executive session is over, now these have to be released. But then the public records law comes into play, and there are tons of exemptions under the public records law. And so it may well be that even though you're saying, okay, we're releasing the minutes, you can still redact portions of them forever if the public records law would allow that.
Okay, so that would be something you just get legal counsel involved with to determine?
If you're, the guidance under the public records law can be obtained from the supervisor of records and the secretary of the Commonwealth's office. They have a lot of resources. They have a pretty robust guide and a hotline, so they may be able to help you. But referring to legal counsel also is always an option as well.
Okay, and I just have one clarification question. When you were saying meeting minutes do not need to be physically stored with the meeting, or the documents and exhibits used by a public body have to be retained but not stored with. Like you were saying, you keep saying release the minutes. Do you just mean like they're ready for anybody to request, or
yes.
you actually have to post?
No. So when I say release, that just means that they are no longer confidential. So if somebody requests them, then they can be provided without having to do a quick review. So usually, if somebody, let's say somebody makes a request for meeting minutes, if it's like a public records request and the clerk just says, okay, this is what I have, these minutes are public, releasing means that the minutes are now designated as public and they can be provided upon request. There still is no obligation that they be posted to a website under the open meeting law. Again, as I said before, the public records law may require that meeting minutes be posted. Okay, so documents that are used by a public body during an open meeting are public records. So again, this is what we were just talking about, that the open meeting law only says that the documents need to be listed, but then you have the public records law, which is a separate law, but it does give members of the public the right to request records. And documents that are used during a meeting and that are listed on the meeting minutes are public records with a couple of exceptions. So performance evaluations not created by members of the public body do not become public records. So for example, if a school committee is doing a performance review of a superintendent and they ask teachers to prepare evaluations, those teacher evaluations of the superintendent are not created by members of the public body, so those do not become public records. And then application materials that are reviewed at a meeting, including by a preliminary screening committee, do not become public, just the resumes become public. So we're going to go through the, yes, question in the back.
Back to the documents. If a public body receives documents to, make decisions, but they're not specifically referred to in the meeting, are those documents still public record?
So this gets a little bit farther afield from the open meeting law because the public records law and records retention laws are broader. So they refer to any document that is created by a public official or a public employee, becomes a record, and it needs to be retained, and then may need to be produced under the public records law. So that's outside the scope of our jurisdiction. the open meeting law only applies to records that are more robustly used at a meeting in the way that we discussed earlier. But it is possible that those types of records, even though they don't rise to the level of being used at a meeting, they still may be considered records that need to be retained in accordance with records retention laws and available if there's a public records request. But that really is a separate but certainly related issue.
Thank you.
Okay, so the open meeting law complaint process. Any member of the public or member of a public body or a state or local official can file an open meeting law complaint. Complaints need to be filed on the Attorney General's open meeting law complaint form that is shown on the screen here. It's available on our website. Complaints need to be filed within 30 days from the date of the violation or within 30 days of the date that the complainant reasonably could have discovered the violation. We say that any open meeting law violation or alleged violation that occurs in open session is considered discoverable as of the date it occurred. So let's say that there is a complaint that there was a discussion at a meeting in open session about something that wasn't on the meeting notice. Somebody didn't go to the meeting, and so they didn't find out until a month later when the minutes were approved that this discussion occurred. But we still say that because that discussion occurred in open session, it could have been discoverable if somebody had been at the meeting. They would have witnessed that discussion. And so the 30-day clock for filing that open meeting law complaint begins from when that violation could have been discovered. So again, violations that occur in open session are considered discoverable as of the date they occur. On the other hand, sometimes violations are not discoverable until years down the road when executive session minutes are released, and then a member of the public says, oh, there was this executive session discussion and I only just found out about it because they only just finally determined that the minutes are appropriate for release, and now I see this discussion that they had and I don't think that was an appropriate topic for executive session in the first place. And it could be years later, but that complaint might still be timely. So the complaint gets filed with the public body. So for local public bodies, it should be filed with the chair of the public body and then a copy sent to the municipal clerks just so that the clerk can kind of track it. But it needs to be filed with the public body itself, again within 30 days of the date of allegation or when the violation could have reasonably been discovered. Then the chair needs to disseminate the complaint to the remaining members of the public body. The public body needs to meet and review the complaint and then needs to prepare a response to the complaint and needs to do all of that within 14 business days from when the complaint was first filed. A public body may request an extension of time for good cause, and that request for an extension doesn't need to be anything too formal. It's just a request that comes to our office, explain the reasons. Oftentimes we grant requests for extensions because the public body doesn't have a meeting scheduled within this 14-day period, and it would be difficult to compile a quorum and hold an extra meeting. So as long as the request for an extension is relatively short, we will generally find that that constitutes good cause for an extension of a week or so. After the public body reviews the complaint, they may delegate responsibility for responding to an individual. It could be legal counsel, it could be just one member of the public body. Sometimes it's the clerk or the town administrator who prepares the response. But again, as long as the public body has reviewed the complaint, it is fine for an individual to be tasked with responding to the complaint. The public body prepares a written response, and it identifies what remedial actions, if any, it has taken in response to the complaint. It needs to send a copy of its response to the complainant, and then also a copy to our office, to the Attorney General's office, along with a copy of the original complaint. So we don't receive the open meeting law complaints when they're first filed. We receive them when the public body responds and gives us both its response and the original complaint. So that's usually the first that we know about open meeting law complaints. Then, if the complainant is not satisfied with the resolution of the complaint by the public body, then he or she may ask our office to review the complaint. So we do not automatically do that. We only review open meeting law complaints and investigate and then issue determinations if the person who filed the complaint was not satisfied with the response, and then they take that additional step of asking our office to review the complaint. So there is a time window when that needs to occur. The complainant needs to wait at least 30 days from when they first filed the complaint with the public body. And the reason for that is that the goal of this process really is that the complainant and the public body can work out the issue by themselves. And so we want to allow time for the public body to receive the complaint and respond and maybe have some additional back and forth discussion. And then only after 30 days have passed can the complainant forward or elevate the complaint to our office for review. And then the complaint needs to be filed with us no later than 90 days from the date of the alleged violation or when the violation could have been discovered. So there's kind of that window of 30 days to 90 days when the complaint can be filed with our office for review. And then once the complaint comes to us, we review the complaint, we conduct an investigation. The breadth and depth of our investigation really depends on the nature of the complaint itself. A lot of the time when the complaint is just about something that happened at a meeting, there are meeting videos which are very helpful. We will review meeting videos or audio recordings of meetings. Sometimes that's all that's necessary. So if there is, let's say, a complaint that a public body discussed a topic that was not included on a meeting notice, or that the minutes are insufficiently detailed, sometimes all that is really necessary is to review the meeting minutes, the meeting notice, a video of the meeting. Sometimes we do much more robust investigations. We talk to various people, we talk to witnesses, we talk to legal counsel, we'll talk to the complainant, we might talk to other members of the public who witnessed a particular situation. So the nature of the investigation really does depend on what the specific allegation is. We then will issue a written determination. These can be informal determinations, which are much shorter, or more formal determinations where we lay out all the facts and do an analysis and apply the law. But either way, we, at the end of it, determine whether or not there was a violation of the open meeting law. And if there was a violation of the open meeting law, then there are various remedies that we can order, which I'll talk about in a moment on the next slide. And then a public body that is aggrieved by our decision, so generally that means that we found a violation, a public body has the right to appeal to Superior Court, and they are essentially then asking a court to review our decision to see if we got it right. So here are a list of some of the different remedies. The open meeting law itself identifies these specific remedies, but we do have broad authority for what type of remedy to impose. And again, we consider a lot of factors when deciding what remedy is appropriate, including the nature of the violation, the seriousness of the violation. The most common order is to compel immediate and future compliance with the requirements of the open meeting law. And if we find a violation, as Carrie mentioned at the very beginning when we talked about the certifications, if we do find the same type of violation by the same public body in the future, we may consider it evidence of an intentional violation. And intentional violations can carry with them a civil penalty of up to $1,000 per occurrence. That penalty is assessed against the public body, not against an individual. It's assessed against the public body. We don't find a lot of intentional violations, maybe a couple a year, but they do happen. And again, usually it's because we specifically issued a decision, warned the public body, and then they did the same thing again not long after. But we can compel attendance at trainings. We do have a lot of training materials on our website, including short video training modules. So sometimes we'll, if the problem was limited to a specific item like minutes or notice or executive session, we can require members of a public body to review a specific portion of our training modules and then certify to us that they've done so. Release of executive session minutes is also, I would say, a fairly common remedy. So if we find that an executive session was improper, especially if a topic was discussed in executive session that was not an appropriate topic for executive session, we can compel those minutes to be released to the public. If we find the minutes are insufficiently detailed, we can require a public body to go back and bulk up the meeting minutes. So a variety of different actions are possible. And then there is a judicial complaint process where instead of using the open meeting law complaint process that we just talked about, 3 registered voters do have the right to file an open meeting law lawsuit against a public body directly in court. Our office is not involved in that, so it's just an open meeting law lawsuit directly brought by 3 registered voters against a public body, and then a judge decides the open meeting law issue rather than our office. We are not aware of many of these happening, maybe a few a year, although it's possible that there are more than we realize because, again, we're not a party to these proceedings, so we usually just hear about them through some other source. So that is an option that could occur. So just a quick review. We talked about the requirements for posting notice of meetings. Meetings need to be open to the public unless there's a lawful executive session purpose. We talked about the responsibilities to prepare and approve meeting minutes in a timely manner, and in particular, the requirements surrounding executive session minutes and the additional responsibility of public bodies to do that periodic review of executive session minutes. We talked about the certification process and then the complaint process as well. So we want to conclude by giving you some resources. We really do have a lot of open meeting law resources on our website. We also have a lot of written materials that are on the table outside. Some of the things that you'll find that are most helpful are some of our checklists. So for example, a checklist for all those procedural steps for entering executive session, that can be really helpful. All of our determination letters, we have a couple thousand at this point, are available on our website in searchable format. And then we also maintain an open meeting law hotline, which is staffed 5 days a week during business hours. Carrie mentioned that early on. The email address and phone number are right here, and we do respond to questions pretty quickly, same day or next business day. If something is really time sensitive about a meeting, in a couple hours, we really do try to get back to people in time to be helpful. So we are available as a resource, and we do hope that helps to avoid some open meeting law violations and just to provide clarity both to public body members and to members of the public who call us asking what the requirements are. So here's just some general information, contact information for the Attorney General's office. And then some other resources, and then here is our Attorney General thanking you for participating in this training tonight. So, Carrie and I will stick around if anybody has any questions. We're happy to take questions. And then also please do fill out the evaluation forms that were out on the table. If you didn't grab one, please take one now. Yes?
I had a question. One, thank you for this presentation. It was wonderful.
Thank you.
And two, what are the commonest complaints or violations that you receive?
Let's see, the most common types of complaints that we receive, I would say, are insufficiently detailed meeting notices.
Oh, wow.
Insufficiently detailed minutes. I'm trying to think what else. Carrie, what else would you say are the most common? Timely approval of minutes is another one. Yeah, timely approval of minutes. And then executive session, so an improper executive session purpose, I would say is also another very common complaint that we receive.
Thank you, that's helpful.